All right, good evening. My name is Dr. John Foran. I'm the director of Miami University's Menard Family Center for Democracy. And on behalf of the university, it's my pleasure to welcome you to tonight's lecture, which is the fifth in the series of Monday night talks on issues of democratic governance that the Menard Family Center is presenting this spring. I will turn over the proceedings in a moment to Dr. Kimberly Hamlin, Professor of History and Global and Intercultural Studies at Miami, who will be introducing this evening's speaker and moderating the post-lecture Q&A. First, though, just a couple of quick housekeeping items. For one, we invite you to participate in the Q&A this evening after the speaker's prepared remarks by posting any questions or comments that you may have in the Q&A function. So if you look at the bottom of your screen, you'll see a Q&A box there to click. And if you click that and then type in your questions, Dr. Hamlin will see your questions and can then present them accordingly. Secondly, closed captioning is available for the event this evening. So if you would like to take advantage of that function on Zoom, please just turn that on again at the bottom of the screen. And with that, thank you for joining us this evening. And let me turn things over to Dr. Hamlin, who will guide us the rest of the way this evening.
Thank you, Dr. Foran. Thank you, all of you, for joining us this evening. I'm so excited to welcome Paula Monopoli here to our virtual Monday evening discussion of democracy. I met Paula in the fall of 2019 because we are part of the small sorority of people who published suffrage centennial books in 2020, and we were on a panel together at the Constitutional Law Center at the University of Akron. And her book was not yet out, nor was mine. This was 2019, but I was so excited to meet her and riveted by her research. I just want to read you one of the small reviews. I could read many, but I'm going to read you by Reva Siegel, who's sort of the dean of legal historians with a focus on gender. She says, she describes Constitutional Orphan by saying, in this path-breaking book, Paula Monopoli bridges conversations in history and law to ask why the 19th Amendment has been overlooked and become a constitutional orphan in the Constitution's interpretation. Her magnificent recovery of this history will enable the amendment's more robust and intersectional interpretation and enforcement in the years ahead. What could be more relevant, right? Especially as we debate the future of the Equal Rights Amendment as well. Professor Paula Monopoli is the Saul and Carolyn Hubert Professor of Law at the University of Maryland, Carey School of Law. An elected member of the American Law Institute, Professor Monopoli received her BA from Yale and her JD from the University of Virginia School of Law. Professor Monopoli is the editor, author, and co-author of 3 previous books, including American Probate, Law and Leadership, and Contemporary Trusts and Estates, as well as a number of articles, including Gender and Constitutional Design in the Yale Law Journal. She has been a visiting scholar at the Moeller Institute, Churchill College, University of Cambridge, and is an academic fellow of the American College of Trust and Estate Council. I can't wait to hear from Professor Monopoli tonight, and I'll be encouraging you to engage more with her work in the chat feature as well. Professor Monopoli, welcome.
Thank you, Kimberly, for that wonderful introduction. I am so happy to be here with you, with John, with our audience this evening to talk about voting and its history in the United States as part of the Menard Family Center's Dialogues in Democracy series. This is a complicated legacy and an intersectional story that involves the connections between sex, race, and class. And as Dr. Hamlin mentioned, I recently published a book on the constitutional development of the 19th Amendment, the Women's Suffrage Amendment, and it focuses on that 10 years, that decade after ratification in 1920. The book is called Constitutional Orphan, and I'll talk a little bit more about what that means in a second. And it was published by Oxford University Press in September, right sort of on the cusp of our commemoration of the amendment in August. The book focuses on the puzzle of why it was a thin understanding of the 19th Amendment that emerged by the end of that decade. And by thin, I mean this sort of narrow It's just about the vote sort of understanding. And that it was not about a broader sort of sense of sex equality or gender equality that came out of that 10 years of contested court cases and judicial interpretation that followed the ratification. And it wasn't a sense that women were given under the 19th Amendment the sort of guarantee that they'd be allowed to engage in robust democratic governance in all of its forms, including not just the eligibility to vote, but engaged in jury service, which was seen as a political right, or holding public office, which is clearly a political right. And so that sort of narrow sense of the amendment is what I was really interested in finding out about and how that emerged in that decade. I also, as I began to do the research, it became quite clear that race, class, gender, obviously, were a huge part of that story, a central part of that story. And I wanted to sort of explore how the amendment implicated big constitutional issues like federalism, issues like the scope of women's citizenship, and the constitutional definition of equality. So this evening with you, I'd like to do three things. First, I'd like to describe and introduce you to some of the women who created this really remarkable shift in the landscape around federal power versus state sovereignty in the realm of voting. And then second, I'd like to talk a little bit about what the people who were involved in this ratification thought the amendment meant at the time of its ratification. And finally, I'd like to talk about what I think the 19th could mean to us today in terms of addressing what some have called the gendering of voter suppression. So I'll talk for about 30 minutes and then I'll open it up for questions and discussion. And looking forward to that, sort of part of the conversation. So this past year, we commemorated the 100th anniversary of the 19th Amendment, but we also commemorated the 150th anniversary of the 15th Amendment. And that was the amendment that enfranchised, at least on paper, Black men. And so that story is connected. And as Dr. Hamlin talks about in her wonderful book, Free Thinker, there's in her article that she did for the symposium that we were at together, there's a deep connection there between those two amendments. Now, we have a representative democracy, and voting gives us our ticket to being part of the group, right, who governs and having a voice. And that group started out very small in our country. So it's grown over time by a series of amendments that we call the voting amendments, beginning with the 15th in 1870, and then the 19th in 1920. And then the 24th, which abolished the poll tax in 1964, and ending up with the 26th Amendment in 1971 that dropped the voting age to 18. So these amendments were needed to the federal Constitution because the Constitution basically says that states control voting under Article 1, Section 4, unless Congress chooses to act. It can act by amendment, it can act by legislation. So originally, again, states were in charge of who was eligible to vote, and they limited voting to white men who owned property. Then they sort of expanded that to white men, all white men, even if they didn't own property, and then expanded that with the 15th Amendment in 1870 to African-American men. So you see the sort of the size of the governing body, right? The people, if you will, growing. And then women fought hard after that. They were excluded from the 14th and 15th Amendment. They certainly fought hard to be included, but they were not successful. And it took 50 more years for them until 1920 to be included in the polity, in the people, in terms of the governing body. And so some scholars have called the ratification of the 19th Amendment in 1920 the biggest democratizing event in American history because it doubled the size of the electorate, essentially on paper. It enfranchised half the adult population. Now, we know now, as we look at the scholarship and the history, right, that Native American women weren't covered by the 19th Amendment because they weren't citizens. Native Americans weren't citizens until 1924. We know that Asian immigrant women were not allowed to vote because they couldn't be naturalized until the 1940s and 50s. We also know that de facto, women of color were prevented from voting when they came to the polls, even after ratification of the 19th, although technically they were covered on paper by the 19th, right? They were prevented by literacy tests, poll taxes, long lines, physical intimidation. So this amendment was accomplished by women who were not in formal political office. They were not members of Congress. Jeanette Rankin was the first and only member of Congress to vote on the amendment, and she voted in the 65th Congress. She was gone by the time the vote came back up in the 66th. These women didn't have the vote, many of them. Some did, some lived in states where they had already given women the vote, but many of them had no vote. And so their feat is sort of amazing, right? They had to rely on other constitutional tools, like the right to assemble, the right to petition their government for redress of grievances, and the right to engage in political speech through lectures in the public square and in print. So suffragists of color did this with the double burden of racism and sexism. And all of these women did this, if you think about it, right, in a pandemic, the flu pandemic of 2018. And what they accomplished was far more than the vote. They engineered a fundamental shift in power from the states under our Constitution to the national government, to the federal government. So I want to introduce you to some of those women that I'm going to talk about and just share my screen with you for a second here. So I had mentioned to you that the reason, I would tell you a little bit about the reasons I chose the title Constitutional Orphan. And you can see from the cover of the book here, this is one of the suffragist leaders, Alice Paul, standing on the steps of the headquarters in Washington, D.C., celebrating the 36th star on the ratification banner here, and some of the members of her party, the National Women's Party, below. So the reason that I had sort of chosen Constitutional Orphan to describe this amendment was twofold. First, it was abandoned by the suffragists, its proponents, its major proponents, the people who had pushed for 72 years to get it over the finish line. Amendments need nurturing, they need support as a matter of constitutional development. And they need litigation, and they need advocacy, they need legislative advocacy. But white suffragists turned immediately to the Equal Rights Amendment. As soon as the fight for ratification was done in 1920, Alice Paul, in particular, and her party shifted over to the proposed Equal Rights Amendment. The other major suffrage group, NASA, turned to voter education. They became the League of Women Voters. So these suffragists who had fought and pushed and supported the amendment to get it through turned immediately to other missions. And in that, they did not spend much time in the courts trying to push for a robust interpretation of the 19th Amendment. The second reason I called the book Constitutional Orphan is that a consequence of that immediate pivot by the suffragists right after ratification was that courts then rarely cited the 19th. So for example, the 19th has been cited by state and federal courts fewer than 700 times. The 15th Amendment, on the other hand, since 1920, has been cited 4 times as many times, 2,700 times. And I argue in my book that this is in part because the suffragists pulled back, didn't keep the pressure on, and as a consequence, there was no enforcement legislation that was promulgated pursuant to the 19th Amendment. We'll talk about that in a little bit as well. And that didn't give courts a chance to hear cases and discuss what the 19th Amendment meant in a full-bodied way. So who are the protagonists here in this story? Well, there are a lot of them. Alice Paul was a young American who traveled to England after she graduated from Swarthmore. And in England, she worked with the militant suffragist Pankhurst, Emmeline Pankhurst and her daughters. And she learned at their feet how to use militant tactics to push for women's suffrage. The suffragettes, as the British militant suffragists were called, which was a term of derision, as a diminutive, right, of suffragist, were incredibly adept at using these sort of radical tactics to get attention to the cause. And Alice picked that up. She was jailed in England which didn't make her Quaker mother home in New Jersey very comfortable or happy. And finally, she prevailed upon Alice to return. When she came here, she joined the National American. And that was the big group of women suffragists. The NAWSA was what the sort of the acronym was. There, she kept pushing them to support a federal amendment as opposed to a state-by-state campaign for women's suffrage, which is the strategy that they had been adopting. She really was young and she was impetuous and she was sure that that federal amendment was the right way to go. It was certainly the more efficient way to go. So finally, she broke with NAWSA and she figured out that she was going to start her own sort of suffrage organization, and it's called the National Woman's Party. It started in 1914, essentially. And Alice Paul picketed the White House. She was the first. They were the first group to picket the White House in a sort of a nonviolent way, civil disobedience. And they continued those pickets even as World War I started. And even the British suffragists didn't do that in England. When the war started, they backed off. And that engendered a lot of anger and opposition by a number of people. These women were jailed in the District of Columbia jail. They were jailed at Occoquan, the workhouse down in Lorton, Virginia. They were force-fed and they were political prisoners. But it helped get attention to the cause. And the combination of this public pressure, the public outcry at these, and they were dominantly middle class and upper class women, although there were some working class women among them, getting jailed and being held in such atrocious conditions really helped turn the tide in terms of public pressure to get President Wilson to eventually support a federal amendment. And again, as Dr. Hamlin points out in her book, another major suffragist, Helen Hamilton Gardner, was working also inside the White House to persuade President Wilson to get support for that federal amendment, which they eventually did. And she had a critical role in that. Ida B. Wells Barnett is operating at the same time as Alice Paul, a Black suffragist who began the Alpha Suffrage League in 1913. She was a journalist, she was an anti-lynching and a suffrage advocate. And Alice Paul had organized a massive march in 1913 when she was still with NAWSA to draw attention to the suffrage movement. And unfortunately, the word went out from, depends on who you sort of read about, but either NAWSA headquarters or Alice Paul herself, that African-American suffragists like Ida B. Wells should march at the back of the line. They shouldn't march with their state delegations. And the concern was on the part of the white suffragists that the Southern white suffragists would be alienated by having Black women march in their state delegations. Ida B. Wells didn't do this. She waited for the Illinois delegation. She joined the Illinois delegation. A lot of other Black women marched in the march, but it was a harbinger, right, of the conflict, the racism that existed among white suffragists who, in many cases, were more concerned with getting that federal amendment through and getting suffrage and disregarded the impact on Black women. And so Ida B. Wells is a major figure in this story. Mary Church Terrell is the leader of the National Association of Colored Women, started in 1904. She, like Ida B. Wells, is a suffrage advocate, is also a voter education advocate. As leader of the NACW, she plays a prominent role in this story. After ratification of the 19th, there's a presidential election. And Black women are turned away at the polls, as Black men had been by 1920 in the South, especially the Southern states. And Mary Church Terrell goes to Alice Paul at an important convention after ratification and says, "We need your support. This amendment will never fulfill its promise if all women don't have the right to vote. You know, come help us in the South, push for a congressional investigation with us. And it's important that that enforcement legislation be supported." Unfortunately, again, because Alice Paul has turned, she's moved on to a different amendment, the Equal Rights Amendment, and she again is still concerned about appeasing Southern congressional white votes. She says no. She splits tactically sort of race and sex. And so that's, again, part of the kind of concern here in terms of the racism among the movement. And I would argue to you, it's not only a moral failing on Alice Paul's part, it's a strategic failure. The 19th comes out with a very narrow understanding after 10 years, and we still don't have the Equal Rights Amendment. And finally, Florence Kelley. Florence Kelley is one of the white women who were co-founders of the NAACP. She is the president or the chair of the National Consumers League, started in 1899. She's a legal progressive who supports suffrage, is in the National Women's Party with Alice Paul. But when ratification happens, she sees what's happening to Black women in the South. She goes to Alice Paul and again asks for a hearing on the floor of this important convention by Black women who are presenting this resolution. She also ends up a fierce opponent of the Equal Rights Amendment because progressives were very concerned with preserving protective legislation for women. They had fought very hard in a case called Mueller versus Oregon back in 1908. Florence Kelley was on the brief. She was a lawyer, very, very good and experienced lawyer. They fought for this legislation to protect women, especially women in factories, from excessive hours and to provide them with a minimum wage. Her concern was Alice Paul's Equal Rights Amendment was going to be used by a conservative Supreme Court to strike down legislation that treated men and women differently, even if it was helpful to women. So she was a fierce opponent, and in addition to sort of pushing Paul to entertain the African-American suffragist resolution at that convention. And my final slide is just to show you the language of the 19th as we talk about it. The text of the amendment here is interesting, all right? You can see the language. It's not a right to vote that's being given. It's a constraint on the states, right? It says the right of citizens to vote shall not be denied or abridged by the US or by any state on account of sex. So it's a constraint on the states. The second section, which is rarely mentioned, is a grant of power to Congress to pass legislation under this amendment to help implement it, to help punish people who don't register women after this amendment is ratified. There's no legislation that comes out after this. And this amendment is, as you can see, supposed to operate on the states. It's in essence striking any state law that says you have to be male to be an elector. And in that way, it's what we call self-executing, that part of it, right? So if the state said to be an elector, you had to be male, this essentially changed that state law, struck out the word male, even though the state hadn't taken any action. So that's the sort of effect of the 19th Amendment. And you can see here the federalism implications. It's shifting power from the states to the federal government in that regard. So let me go back here and talk a little bit about what happened here. What had come before 1920? The women's movement started, depending on which historians you read, in 1848 at Seneca Falls as a broad movement, as a movement to help women control their property, to make contracts, to have custody of their own children, to abolish the legal regime we call coverture. But to get the diverse range of women on board here, with all of the divisions, different classes, the racial divisions, right? They narrowed this movement over the course of the 19th century to focus just on the vote. What they thought they were seeking was political liberty, and the apex of that political liberty was the vote. But they also believed that it would give them the right to self-govern through participation in all of the political rights that one needs to self-govern, including jury service and holding public office. So this part of the story, right, implicates the scope of women's citizenship. What emerged about in the decade after the 19th Amendment was a partialized citizenship. Women only had the ballot for the most part and not these full political rights. That's how many courts construed it, all right? So that's part of the story here too. And again, this kind of effort, right, on the part of the women's movement reflected the fact that women after ratification sent, for example, Alice Paul got a telegram from one suffragist who said, "The long struggle of American women for political freedom is at an end." And again, they use these phrases: political liberty, political freedom, self-governance, democratic governance, right? And remember, in the 15th Amendment, after that was ratified, enfranchising Black men, there was enforcement legislation that was passed. A number of civil rights acts were passed using that as its authority. Those specified that jury service was to be provided to Black men. They were not to be denied jury service. Holding public office, interfering with an African-American man who was holding public office was covered. The people in 1920 were familiar with what a federal voting amendment looked like back in 1870 and how it had developed over the years. Pro-Congress, pro-suffrage congressmen said things like, women are equal partners in the state as well as in business and the home as a result of the 19th. And once it left Congress and was sent to the ratifying legislatures, those state legislators, like Tennessee House member Tom Riddick said, if women are human beings, why shouldn't the first sentence of the Declaration of Independence apply to them, which said that all men are created equal? And even the anti-suffragists in that Tennessee legislature, who eventually were defeated because Tennessee was the 36th state to ratify, said things like, I would not pollute women by allowing them to wade through the filthy waters of politics. So there was an understanding on both sides that this would allow women political governance rights. So I think that's one of the important things that I sort of want to communicate here in our dialogues on democracy discussion. This was about democratic governance. It was about other things as well, but everyone sort of understood that it was to make women equal participants in democratic governance. Then it went to the state courts after those sorts of steps, right? So it comes out of Congress, it's passed, it's ratified by the state legislatures, and then it goes to the courts to decide how it's going to affect their laws. And in one Michigan Supreme Court, the Michigan Supreme Court in one case said, what was the purpose and object of this constitutional amendment? The moment a woman became an elector under the federal constitutional amendment, she was entitled to perform jury duty. If our state law says electors are the class from which we select jurors, once the federal constitution makes her an elector, basically she gets jury service. That was one set of state courts. Another set of state courts, limited in my home state of Massachusetts, there was a Supreme Court decision where they basically distinguished those cases that had come up under the 14th and 15th, which said that Black men were entitled to sit on juries. And they said those were different, that the purpose of those statutes was about the formerly enslaved population, right? It was focused on Black men, and that you couldn't sort of extend those cases to this 19th Amendment, which was focused on a different group or enfranchised a different group. So I think that that's an important sort of point is, what happened afterwards. What happened in 1920 in November was a presidential election. The 19th Amendment had been ratified, but all women were turned away in some states, Arkansas, Georgia, Mississippi, and South Carolina, because the ratification had happened right after the registration deadline had passed. Black women were turned away in huge numbers in the South in November 1920. And one view of legal history is that it's really important when you look at a movement like the suffrage movement to look at the sustained pressure of that movement. When the reform movement pulls back, courts resort back to stereotypes. And I think in part that's what happened here as these suffragists pivot quickly from suffrage to other missions. And again, Alice Paul turns right away in February 1921, very quickly to the Equal Rights Amendment. In 1921, again, as I mentioned, it was important to acknowledge, for us to acknowledge that Alice Paul chose not to continue to support not only the calls for a congressional investigation of Black women being turned away at the polls, but enforcement legislation, which would have helped the situation in the South. She had supported it, and then they quietly, her party withdrew their support. Again, turning to the ERA, wanting Southern congressional votes for that amendment. And you have to look at splits in these movements to say what happened to the 19th. The split here post facto was between what I call the neutrality suffragists like Alice Paul, who said, all we need is the law to be the same for men and women. Just no difference. That's all we need to have equality. And people like Florence Kelly, who I introduced you to in a few steps back, Florence Kelly said, no, that doesn't get us equality, right? Women are differently situated. They are subordinated, they earn less, they have less negotiating power. They need special laws, special protection. They were the social feminists. And that bitter battle, that opposition to the ERA in those years after ratification of the 19th took energy away from developing the ERA. These women who had been allies got tangled up with some of the legal lights of the day, like Felix Frankfurter, and that hurt the 19th Amendment, took energy and attention away from it. So that after that decade of very thin and narrow understanding, it was just about the right to vote, that was all. And so finally, what does that mean for us today? What's the legacy of the 19th Amendment? We could use it for voting rights and beyond today. First, it has an expressive dimension. It's the only place in our Constitution where we make an explicit commitment to sex equality, right? It reminds us that women were constitution makers too, and that this country had this 72-year conversation about gender equality in the public sphere, and we chose to retrofit our written constitution in 1920 to express that commitment to sex equality. We promised full political rights and robust participation in democratic governance. Secondly, if we look at the 19th as a commitment to allow us to participate as full citizens in democratic governance, including holding public office, right? Some of the laws that are being promulgated in states today limit access to the ballot disproportionately for women. Women change their names more frequently than men, so social naming norms. Women have different responsibilities for children or for elders, and women still suffer clearly from a gender pay gap. So voting access matters to women, right? And so we should think about when these laws have a disproportionate impact on women, using the 19th Amendment as a way to ameliorate that disproportionate impact. And for example, a single day voting system where women have a disproportionate number of responsibilities for children, for example, it has a negative effect on their ability to vote. Recently, there was a federal district court which, for the first time since 1937, addressed a direct 19th Amendment claim. Two Black women in a case in Florida who were being reenfranchised, and then there was a state statute which said they had to pay all of their fees and fines in order to vote. And they provided significant empirical evidence about Black women being most disadvantaged by the gender pay gap, having the most significant difficulty finding work after incarceration. Those are the kinds of disparate situations, social, economic conditions that women still face. And so we could use the 19th to at least scrutinize some of those laws that disproportionately prevent women from accessing the ballot. If courts are not willing to do that, then we should think about enforcement legislation. The Civil Rights Act of 1964, the Voting Rights Act of 1965 were important pieces of legislation that came out of the 14th and 15th Amendments. There was none. Enforcement legislation died in Congress when the suffragists withdrew their support in 1921. And we should think about whether or not we could have a new Voting Rights Act for women under the 19th, under Section 2 of the 19th, or we could amend the Voting Rights Act to include sex as a criterion. It's not in there currently. That would allow for intersectional claims for women of color who are doubly disadvantaged and multiply marginalized based on race and sex. And then finally, we should think about whether some of this legislation might help women. For example, H.R. 1 pending now in Congress has a provision that allows campaign funds to be used for childcare expenses, which is particularly helpful and supportive for women candidates. So we should learn these lessons of 1920, right? It is possible to use the 19th today in a litigation strategy to help redeem it from some of its racist past and change the legacy of the 19th Amendment that way. And we should find common ground. We need to acknowledge that the racism of the suffrage movement existed and that the lack of solidarity among suffragists was a moral and a strategic mistake that weakened the amendment and that spelled failure for the Equal Rights Amendment. And we should pick up what could be a potent constitutional tool and fulfill the promise of the 19th Amendment that all women are guaranteed robust political participation in democratic governance. Thanks.
Paula, that was fantastic. Thank you so much.
Thanks, Kimberly.
A lot of great questions in the chat. So I will ask them and group them together to the extent that we have some in common themes. The first question: the story of the 19th Amendment seems to me to be a story of the failure of the federal courts to give life to a part of the Constitution. Do you think we put too much faith in the courts to protect rights?
That's a great question. I think that there are other ways, right, to go about amping up, if you will, the power of the 19th Amendment. I am not sure that this kind of strategy in terms of bringing claims under the 19th Amendment, while I think it could be part of a powerful campaign to give the 19th its full potential today, is the only way that we should go about it. So yeah, I think we do often resort to the courts, but they have often been, in, especially in voting rights, the place that great people have to end up, especially when you're navigating state laws and these constitutional amendments. But I do think that thinking about legislation is critically important, what that could look like under Section 2 of the 19th. We just haven't explored it to any great degree. So I think a multi-pronged strategy, voter education, targeting people who are not likely to vote, especially, and getting them to understand what's available in their state is really important. I think that was particularly important in this past election, voter education as a prong. So yes, litigation in the courts are not the be all and end all of vindicating constitutional rights, but they're an important piece, right? In the end, that's where you have to go if the other parts of the strategy aren't working.
On a similar theme, another attendee is wondering what lessons can be derived from the story of the 19th Amendment, those seeking judicial protections for the rights of others today who do not have sufficient political power to protect their rights in Congress or in state legislatures. What lessons from the 19th Amendment can be gleaned from others who don't have sufficient political power to protect their rights?
Yeah, it's a great question. There are discussions, and Kimberly, you know this, about whether, even if we had, for example, enforcement legislation, would the social conditions of the time have prevented the 19th from being used, for example, to help vindicate African-American women's rights in the South? And it's a really important historical question. But I think at the very least, if more of an effort had been made to work together, and there were white women suffragists, as I mentioned, Florence Kelley, Mary White Ovington, who were co-founders of the NAACP, on a strategic litigation strategy, in addition to trying to move legislation through Congress, that there would have been more progress. Wouldn't have been a panacea. It was 1920 was the height of Jim Crow. We're not being, I think, but it's amazing that the suffragists did what they did. They got that 19th Amendment through a Congress where there was deep opposition from Southern senators, right? And they beat back amendments that would have limited it to white women. They beat back amendments that would have gutted the enforcement power. They got the enforcement power included in the first place. And none of them were in Congress, right? We just had, Jeanette Rankin for one term right around that time, and she wasn't there when they took the final vote. So I think we can't forget how much they did accomplish with this, they kept that pressure up. They had resources, they deployed them. So I think for the lessons for today, for people who are not empowered, is, that solidarity matters and consistent pressure matters. And politicians fold, right? And as you know, there were 15 states where women could vote before 1920, and 12 more where they could vote for presidential electors. That mattered to politicians. So the suffragists played a key role as institutional actors in civil society, but politicians, at some point, it became a good thing for them to have women, right, voting. And that's a story, right, about racism, where they understood that it would dominantly be white women voting and not Black women voting. So I think that's the lesson, is the pressure of the movement has to be consistent. When you let it ebb, you lose ground, and that you have to try to avoid splits in the movement. That diminishes the power. So I hope that's responsive.
Yeah, that's great. And one thing I was thinking too, that suffragists did so well to help the 19th Amendment get through Congress finally in 1919 was defeat strategically 2 anti-suffragists in the 1918 election in the Senate. So that they didn't change hearts and minds so much as they ousted the antis when the time for changing hearts and minds had concluded. So I think, and again, they did this in states where they couldn't vote, but by canvassing husbands, sons, but it was Massachusetts and Rhode Island.
Yeah.
So that was a really powerful strategy.
And that was, so interesting, right? That we talk about the Southern states, but that opposition, right? The 2 senators from Massachusetts before they defeated that were both against suffrage. Massachusetts was a heavily anti-suffrage state. We think, oh, and they were Republican senators, right? Who were generally more supportive than Democrats in those days of the idea. So yeah, it's a great point. They use that power to actually change the votes. Absolutely.
We have a couple others on this sort of theme of voting rights, lessons learned for today. Another attendee is wondering if you have any thoughts more generally about recent attempts to cut back on the ability of marginalized communities to participate in voting.
Yeah, and with as I was wrapping up the book and doing that final chapter, I became aware of the Florida case. It's Jones versus DeSantis is the case. And as you know, we saw one of the women who is at the Southern Poverty Law Center who brought that case and put that 19th Amendment claim in. And she's amazing, Nancy Abudu.
Yes.
And so I think that these are incredible efforts on the part of lawyers to evaluate these laws as they're coming through legislatures, to say, they intersect with social conditions, economic conditions in ways that depress the vote, and we have looked at those cases generally through a racial lens, which is appropriate, especially given the Voting Rights Act, which is built around race as a criterion. But what's so interesting is to look at it, some of the scholars who've written about this, like Celeste Montoya, have talked about, there's been very little attention to the gendering of voter suppression. So yeah, I think that if we can start to look at how it affects women, and especially look at that intersectional amping up of Black women, the harm, right, that's being caused, that we can begin to think about those in a different constitutional way. So I'm kind of, I have hope that perhaps courts will entertain these claims. The district court in Jones versus DeSantis said intentional discrimination has to be established. That's awfully hard to do in these cases on the kinds of laws that we're talking about. And it could be that some of these laws, I'd like them to at least get before the court, which is the problem with the current standard. Some of them may have more impact on women than others as a class, right, as a group. But I think that it's really important for us to keep the pressure on looking at each of these laws and saying, is there a rational reason why this is necessary? Because in many cases, the harm, it certainly outweighs any arguable rationale for the rules, especially when you look at it through that intersectional lens of race and class. It's really keeping a number of voters away from the polls.
On the same topic of voting rights, another attendee is wondering if you could speak to a litigation strategy about breathing life into the 19th Amendment versus other types of activism, such as a political organization, perhaps at the state level. Can you talk a little bit about the various strategies that we could adopt and help us weigh the pros and cons?
Yeah, so I think the cons of a 19th Amendment litigation strategy are what I just mentioned about the current
Mhm.
jurisprudence on voting rights. And so that's a problem. And again, it's not my area of expertise in terms of all of those strategic choices that voting rights lawyers are making. But I think that there's a kind of an uphill battle with bringing claims, what we call direct constitutional claims. So bringing a claim under the 15th Amendment or bringing the claim under the 19th Amendment, as opposed to bringing it under enforcement legislation. The Voting Rights Act has within it a lower standard under Section 2, where you can prove a disparate effect or a disparate impact and have that be a claim. Direct constitutional claims are held to this very high intentional discrimination or discriminatory purpose standard. So litigation strategies are tough if you're bringing direct constitutional claims. So I do think that, as I said, the other kinds of prongs, maybe working on legislation in this regard, either in Congress or at the state level as well, right? States have constitutions. States have equal rights amendment in their constitutions, some of them. We don't have a federal ERA, but we do have state constitutions with equal rights amendments in them. I mean, there may be really interesting state strategies where we're using state constitutions as well as federal enforcement legislation. And then again, voter education, I think is key. And as you point out, Kimberly, right? If you can get out and vote and the legislature and you can change representatives, that's another sort of part of that strategy.
Right. Great. Thank you. We have a couple questions that want to take us back in time a little. And two attendees, Daniel Young and another, are wondering if you could help us understand why some women could vote in some elections sometimes in certain states before 1920.
Yeah, this was a fascinating part of the research. And I think so little is done in law schools on the 19th Amendment, at least today. I think it's actually mentioned in constitutional law case books. When I went to law school, I'm not even sure we mentioned the 19th Amendment or that it was in the case book. So we had very little understanding, I think, most Americans, that 1920 wasn't like a light switch where all of a sudden women could vote. None of them could vote. You know, the history of women voting, there were women in New Jersey who voted right after the Constitution, right? Back in 1789. So, and that kind of then went away. But the newer movement to enfranchise women, because the Constitution essentially left the time, place, and manner of elections to the states, they were making the rules about who was eligible. You know, throughout the early 19th century, up until we see again the Civil War in 1870, the 15th Amendment, that was the norm. And so some states, especially Western states, had chosen to enfranchise women. And, you know, there's been lots of great history written about why. But, you know, some theories are that, you know, there were very few women. And so if you wanted to sort of attract women, you know, and you would give them the vote, if you wanted to sort of recognize the fact that they were working in equal, difficult, right, jobs on ranches and way out in the middle of nowhere, that it made more sense than it did back east, where again, Massachusetts and New York were very uptight and regionally were not going to support suffrage. So I think there were different regional conditions. That's such an important part of that story that allowed or provided for certain states to move first to give women the vote. And again, they tended to be the Western states. Utah and Wyoming, I think, were probably in the early, right? There was a little bit of a debate about which was actually first. I think Wyoming was technically first, but Utah, the woman actually cast the first ballot. So that was the sort of story. And we didn't understand that, I think, as we were looking at this, you know, all through the 20th century, that story got lost. I mean, that's what drives me to write this story, is you're trying to sort of, right, remind people of this lost history. So there were those states, they were different regional conditions, different political conditions that gave rise to state by state suffrage. There were suffrage campaigns on the part of national groups and state groups, state chapters, that caused that to happen. And then there was this partial voting, which again, we just sort of, we didn't learn about, right? That women could vote for presidential federal elections, I guess, presidential electors, but not in state elections, for example, or they could only vote in local bond elections. Little, sort of women must have an interest in schools, and so they could vote on the local bond issuance, but not big issues. So again, partial suffrage was a strange idea, when I first sort of ran across it and realized, yeah, that was going on a lot, right, before 1920. So that's I think it's regional conditions, different political conditions, different sorts of valences, right? So, but we should teach it better.
Actually, that's the perfect segue to our next question, which I too have thought and published and written a lot about, which is, why isn't the history of women's suffrage given more attention in K through 12 history and civics courses? Here we are, Women's History Month. Why are we still a sidebar?
Yeah, oh, it's such a great question. So I think it has to do with this narrative, right, that became the dominant narrative about the 19th Amendment generally, which is everything was solved. Women just needed to vote and they got it. And that's all it meant. And that's, no more discussion, right? And that narrative became the dominant narrative. And I mean, that reflects the simplification of women's history generally, right? That had that didn't start to the complicated history of women in this country didn't start to be told and written by scholars until the 60s and the 70s, right? But that 19th Amendment story was a very simplified narrative of what had happened. And so that's, schools pick up on that. It signals something to the society about the importance of this issue, the importance of women. I've had more people say to me, what amendment is that? Right about the 19th, right? You had this, which one is that? I had someone tell me, well, it was a great success. Like, women just voted. Like, well, it's a little more complicated than that. And so that's the great thing about the commemoration of the centennial, which got eclipsed by the pandemic. But I hope we can continue it a little longer because, right, it got a huge coverage in the press. The people, who are writing articles, writing books like you and I think are now trying to sort of, emphasize the story and talk about this with our students, with our colleagues, getting our scholarship out there with the broader public, right? And I do think that it hopefully will create an important change, especially in that K-12, but even in higher education, in law school, right? It's I think will be a bigger topic, at least among my colleagues who teach law. I hope so.
I hope so too. I know I promised I would put things in the chat, but we don't have a chat, I see. If we did, I would share a link apropos of this discussion and some related questions that have come up about history standards, women, stories that are lost. And that the link would be, if you want to Google it later, is the National Women's History Museum conducted a comprehensive report of state standards and textbooks in 2017. And the results are really disappointing, right? And how women are included in our state standards and our textbooks and what can be done about that. So I would encourage anyone who wants to read more to Google that report later or email Professor Monopoli or I. Now we just have a few minutes left and we have a whole host of questions about the Equal Rights Amendment. So I'm going to paraphrase them and have that be kind of our big picture, deep thought that maybe will end tonight's fascinating discussion about. So one attendee is wondering what would be different as a matter of constitutional law if we added the ERA. Another is wondering how do we overcome the pushback against gender and rights discrimination that stalled the ERA the first time around? Do we have a better chance now than the 70s and 80s? Another attendee is wondering, should we have faith that a fully ratified ERA will make a substantive difference in gender equality in the real world? So it's a lot of questions. Pick whichever speaks to you, but I think they're on of what can we hope for? What might be different if the ERA was ratified?
Yeah, so I mean, technically, right, if we had an equal rights amendment in the written constitution, the federal constitution, it would amp up the scrutiny of any law that the government enacted that treated men and women differently. So laws that treat men and women differently right now are treated under what we call an intermediate level of scrutiny. Laws that would treat people differently based on race is subject to higher scrutiny. It's harder for a state, for a government to support such a law, right? To argue, to justify such a law than it is for them to support or justify a law based on that treats people differently based on their sex. So an equal rights amendment would amp up the scrutiny for any sex-based differences laws to that strict scrutiny level. So it has an effect that makes it easier for courts to strike down such laws. So that's its technical import. But I think it also has this expressive function. So many constitutions around the world have explicit, right, promises of equality based on sex, right, written into their constitutions. Ours, I keep saying the 19th does that, but it's not as broad, right, as we might want. One could argue that it's limited to political rights and not civil rights. I don't think that's true, but you could see where the Equal Rights Amendment would cover laws that discriminate legally, laws that discriminate based on economics, right? Social conditions. It would be a broader sort of promise of equality. What stalled it again was a lack of solidarity. There were again all those years. It was the Republicans who supported the ERA, not the Democrats, because the Democrats were the sort of the party of the South and they resisted. But it was also progressives who fought against the ERA, and trade unions fought against the ERA. And so there were lots of forces. And then, I think African American women in the movement in the 60s felt excluded, that this was a middle class feminist movement. They were not, right, brought in and were not made part of it. So we can learn those lessons this time so that it doesn't stall, I think. And again, the sides have switched a lot. Things have flipped in terms of which party supports the ERA. But I think that that's avoiding stalling means solidarity. It means inclusiveness. It means, right, recognizing that African American women are in the vanguard today of political change and progressive change. And then, in terms of the equal rights, thinking about will it be effective? I mean, law only goes so far. The written constitution is there, depending on who you talk to protect you from an overreach on the part of government, which I think is true. But I also believe the written constitution is there to help protect substantive rights. That hasn't been a view that the US courts have adopted. I think especially with a feminist constitutionalism, that would be the hope, is that courts would enforce, right, the kind of substantive conditions on the ground that are necessary to get to equality, right? If you are struggling, as Florence Kelley said back in the 1920s, in a factory earning, 17 cents an hour, and you can't feed your family, and you've got, you're living in horrific conditions, don't talk to me about equality, right? And I think that that's the hope, is that, again, the courts are there. They're there certainly as a backstop. Many of us would like them to be more of a protective of an actual positive right under the Constitution. So I couldn't promise that it will make a difference on the ground, but I think it's important. My fear, however, is that even if we get the deadline removed in Congress, that it's not going to be met by a terribly friendly set of courts if it goes into more litigation. And so maybe it for a while, it's good to have Congress debating what it means. And because I don't think that once it gets to the courts, we're going to see a whole lot of progress on that front. So we do have the 19th. That's why I keep going back, right? So if we can't get that sort of protection, what do we do? We have to vote, right? We have to participate. We have to hold public office. That's how you create policy change. So the 19th is really important. It's important on its own, but as we're looking down maybe years for the ERA to really come to fruition, we got to use what we have. We've got that commitment to sex equality in the Constitution. and democratic, the promise of our participation in robust democratic governance. So that's why I come back to that sort of point all the time.
Thank you. Professor Monopoli, you have given us so much to think about, and personally, some more hope for our democracy. I really appreciate how you talked us through so many complex issues. I have learned so much. I know all of our attendees have as well. We also want to thank Dr. Foran and the Menard Center for convening us, and we want to thank the Miami community for such a robust discussion and so many fantastic questions. I encourage you to engage with Professor Monopoli's research by following her on Twitter at Prof. Monopoli. You can go to her website at the University of Maryland Law Center. You can also buy her wonderful book, Constitutional Orphan, any place books are sold, and I encourage you to do so. Professor Monopoli, we thank you so much for joining us this evening.
And thank you so much. It's been wonderful to join you all.